Hey guys, what's up? I think somehow my audio is being duplicated. Oh, there it is. My bad. Sorry about that. What's up? Welcome to Lawsplaining. This is the wrong one. Here we go. Here we go. All sorts of terrific technical acumen is happening right in front of you guys. So, yeah, welcome back. Welcome back to the stream. Hold on, let me get the chat here. I am not even prepared. Not even prepared. So what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta. I own a law firm in central Minnesota that is Rekieta Law. This is the only legal live stream on the internet where a lawyer gets drunk and reads a bunch of documents, and if it's not the only one, it's the only one worth watching. So, we left off yesterday. We left more Aladdin songs. 420 Blaze It says more Aladdin songs. I haven't even started drinking yet, man. You're gonna have to give me some time. And yes, I am back to my wonderful room full of man piles. And if you don't know what man piles are, please check out the latest episode of The Dick Show, where he adequately describes the proper organizational stylings of men. Let's see. There's something here. Alan Foster asks, are we starting with gun talk or singing? Just want to know so I can be prepared. Whatever you guys want. Nicholas Melchiori says, Canadian money isn't real money. That may be true. 3 steel reserves deep. Get with it. Hashtag respect for that. I will start. I'm going to start with something in just a second. This is very important. Last night, right at midnight, we broke out a special bottle of scotch, and both Lady Rackets and I gave that bottle of scotch a try. It was phenomenal, but my glass was lightly tainted because I had started in the same glass with a Balmore 15. And so today, I want to give it one more chance and give it, this time I've added a little bit of water to the glass, and I'm going to go ahead and take a drink. And yes, Ben, I have seen that video. Can you feel the love tonight? We'll see if I can feel the love tonight. We'll see. We'll see. Not in that way. Lady Rackets is glaring at me. Let's see. You better be at Road Rage, Texas. I hope so. I hope so. Apparently, the Dr. Phil Foundation is calling me right now. I have a hard time believing that. But we're going to turn off my ringer here. What? Bare necessities. Oh, gosh. Guys, the Disney repertoire. The Disney repertoire. I am hoping to make Road Rage Texas. It really depends on when that is happening. I would like to be at Road Rage Boston. I would love to go to all of the Road Rages, but logistics. Boxers. What? Since when can dogs use phones? I don't know. Let's see. So here we are again, guys. Oh, let me this is the 25-year special edition Dalwhinnie. Legal briefs. Thank you, Hat Buckles. That was hilarious. And we're going to give this a little bit of a shot. And I put just a tiny splash of water because I found out reading the bottle after drinking it that this was this is a cask strength bottle as well. So can't just drink it willy-nilly. You gotta give it a second. I know. I told her the fans are demanding that she appear on stream. So let's see what we got. Guys, this it's just
so good you choke on it.
It's sweet. But it's dry. It's almost this is an inadequate description, but it's a champagne-like scotch. It's got a dry feel in the mouth, but a sweetness to it. It's good. Strong recommend. Come visit me. We'll share some. All right. All right, guys. Let's pick back up. So if you remember yesterday, we were about here in this disastrous response to Weber Shandwick. If there are two Heathers S working at Condé Nast, does that change anything? Maybe. I don't know. But I don't know of any other Heather S that's currently working there. We're going to talk about that Heather S thing in just a little bit. Zor18 says GFY. You too, buddy. Right back at you. Is Magners Irish cider an okay substitute to whiskey? I ask only because I have no whiskey and I'm drinking Magners. Well, of course. If that's what you got, then that is adequate. And you should never feel shamed for what you're drinking unless it's Fireball. So we were going through this train wreck of a of a response to Weber Shandwick, in which, in pure LanDUI form, he put together a 25 to 30 page rambling document which cites back to his own complaint as if it matters. Woodford Reserve Double Oaked Great Bourbon. Yeah, I do need to try out a couple other bourbons. I've got a bottle. Well, I'm now pretty well stocked on whiskey for a while, so we'll see when I get around to some new bourbon. But it's gonna happen. But yeah, he has basically cited to his own complaint. He has not cited to any affidavits in any effective way, and his case law citations are often completely incorrect. So by the end of reading it yesterday, wherever we left off, I was a little burned out on all of the citations back to the complaint and was uninterested in his lack of argument. And I was hoping that we would see something a little better. I mean, I know that he's not great at this. That's pretty evident. But you would expect him to get... I mean, I'm offering these free online classes that he could take on how to improve his documents, and he's just not getting the lessons, guys. So we need to help him out. Nels Eklund, what are the odds that LanDUI only realized just now that Santer doctrine doesn't apply when you're suing people instead of dogs? Any new docs in the pipeline other than the copyright case? Yeah, Weber Shandwick still has to do their response to this disaster. So we'll see how that goes. I mean, Weber Shandwick's first response to their initial motion to dismiss, I should say, was absolutely brutal. It was before Greenberger's response to LanDUI, the funniest thing in the LoLsuit so far. It was very scathing and very angry. I get the feeling that they are not happy that some dork in New York is trying to drag their brand through the mud based on a personal vendetta from a fraudster and a liar. That would be Maddox. So what are the new documents about? Are there new documents in the LoLsuit case? I've been gone all day today. Let me check and see if I missed something. Let's see what we have here. Forgive me. I said I have not been... Oh my goodness, there are. What? Or wait, no. These are something different. Okay. Hold on. I am researching on the fly. Like I said, I didn't know this. In the motion. Give me just a second, guys. Sorry, I wasn't aware that there were 3 new documents here. What do we have? Okay. Okay. So here's what's happened so far. Wait, just a second, woman. Okay, so basically, Weber Shandwick and LanDUI have made an agreement to extend Weber Shandwick's time to respond to March 27th, which gives them, well, let's see. Yeah, so the time to respond is March 27th, and the adjournment date is March 29th. That's when the judge will start reviewing everything. So, unfortunately, I was hoping we would get another document from Weber Shandwick on the 15th or 14th, but now it looks like that is going to be pushed back to the 27th at the latest. So we will see. That'll give us some different topics to talk about next week. As for the trademark, I haven't checked the status on that today. Let me check real quick and see if anything has happened. And I know you guys love when I am reading stuff that you're not looking at in a completely unprepared fashion, but that's what you get when you let your heart win. So, yeah, there's really nothing more to the documents. They're just documents stating that the adjournment date is being adjusted. Motion sequence number 3 has been adjourned to March 15th. That is okay. In the motion submissions part, for the submissions of hard copies as an e-filed motion assigned to a judge who requires working copies, we are asking that you bring all documents previously e-filed in relation to this motion to room 130 at 9:30 a.m. on this date. That would be March 15th. That is motion 003, which is motion 003. Is that Patreon? No. Motion 4, motion 3. Yeah. Patreon is motion 3. So Patreon's adjournment date is March 15th, which, that means that the judge will have roughly, if I understand it correctly, 30 days from March 15th to render his decision on the Patreon motion to dismiss. We should be seeing a result on the Asterios motion to dismiss, I believe, as early as next week. What's this? Anyone know when the stream starts? So that's where we're at right now. Just you have other options. You have other options here.
I feel trapped.
You are trapped. Just walk past. I'll run a screen.
Super weird.
You want me to blank out the screen for just a second?
It's even more weird. I'll just do
Have you ever tried
stairs.
Aberlure Abunda? No, I have not. But Aberlure was just go. Just go. Quick. Walk past. Walk past. Go. Go run. Anyway. Hopefully she'll come back a little bit later. We'll see. We'll see. All right. So let's get, now that all of the distractions are out of the way, and by distractions, I mean those other documents, certainly not Lady Rackets, who is never a distraction, except when I have a bunch of stuff to do. Let's get back into these and finish out this catastrophe, because we have some other things to talk about. She can just crawl on the floor under the camera. Absolutely. She could have, but she didn't. What?
I just need a chair over there.
I don't have a chair over there.
I know.
Go get one. Oh my goodness, you're going to be in here? This is annoying.
It's much easier for me to read here.
She likes to, well, you guys, you've seen this room. Do you think there's a possibility of crawling on the floor? You have to tiptoe across. It's a minefield.
Have you guys seen Die Hard with the glass on the floor?
Yeah, she is Bruce Willis. So let's get through this document and then start talking about the fun stuff. And Are you really going to make the crawl on the floor on her birthday? No.
Who says I haven't already? Oh, wait.
Wow. Okay, so plaintiff's complaint adequately alleged a cause of action for negligence against defendants Weber Shandwick and Joshua Kaufman, which is a bit presumptuous, I think, if we're honest here. The duty of care owed by Weber Shandwick and Kaufman under plaintiff's cause of action for negligence is not amorphous or wide-ranging whatsoever, as contended by defendants. Are you Bruce Willis's wife? Yes.
He wishes.
Yes, I am. The eminent legal scholar, Judge Benjamin Cardozo, in Glanzer v. Shepard, 1922, instructed that it is ancient learning that one who assumes to act, even though gratuitously, may thereby become subject to the duty of acting carefully, if he acts at all. Okay. This formula was articulated in H.R. Mock Company versus Rensselaer Water Company as follows. If conduct has gone forward to such a stage that inaction would commonly result not negatively merely in withholding a benefit, but positively or actively in working an injury, there exists a relation out of which arises a duty to go forward. The query always is whether the putative wrongdoer has advanced to such point as to have launched a force or instrument of harm, or has stopped where inaction is at most a refusal to become an instrument for good. So, guys, he's pulling out Cardozo, who's a very commonly cited tort litigator in textbooks because he was a legendary attorney and then judge, and is responsible for a lot of how tort law works out. So if you hate the way that lawsuits work, you can just blame Cardozo. And then he's citing a 1928 case. So he's stating that their failure to act was likely to cause some sort of harm. The problem that he's really facing is he has failed to allege that harm has actually occurred in any sense. No, she is not drinking orange drink. She is drinking an Arnold Palmer tonight. So made with sweet tea. So let's see. He hasn't alleged the actual harm. He hasn't done anything to show that the harm that they're talking about has occurred, and he doesn't do anything to show that the actions or inactions of Weber Shandwick proximately caused the harm. It would actually be really hard to do that in this case because all of the alleged intervening action between Dick Masterson, Asterios, Madcucks, and the fans would make it hard to paint the negligence of Weber Shandwick as the proximate cause for Maddox's injury. Anthony says F for Florida gun age increase. Also, Weefeek is gay. Yeah, the gun increase thing, I guess it was bound to happen. And everybody's over there like, well, you got to be 21 to buy a handgun and 18 to buy a rifle. That doesn't make sense. And I'm like, yeah, that doesn't make sense. Why don't you have to be 18 to buy a handgun? Because I am not I am not for unequal treatment of guns under the law. I am for absolute equality of guns under the law, and that equality should extend towards liberty, not away from it. Quoting Clarence Thomas, who is a man of few words on the bench, but he said it recently pretty well that the Second Amendment is a disfavored right in this court, referring to the Supreme Court and their inability to act on some of these things in the past couple weeks. And that's a real shame. So I'm hoping we get some case there. My motions got super long since I bought a standing desk. Standing on two paws gave a huge jump to my productivity. Plus I can reach the semicolon key now. You have like like a junior high English student who has discovered the semicolon, you have used it prolifically, albeit not proficiently, my friend. Moving on. Don the silly hats. We'll get there. At this time, would you ever run for Senate or Congress? I don't know. There's a pretty implicating video of me out there on YouTube. So I think my Senate and congressional careers are done, guys. LMAO at Anthony. Also, Weefeek is gay. Man, Weefeek. Poor guy. Getting the... well, maybe it's not poor. I guess I shouldn't assume that. If Weefeek is actually gay or gay and identifies in that way, then that's just shout outs at that point. The Court of Appeals in Parvey versus City of Kingston held that the case law is clear that even when no original duty is owed to the plaintiff to undertake affirmative action, once it is voluntarily undertaken, it must be performed with due care. And they are not referring to affirmative action in the hiring of underprivileged minorities sense at that point. They're actually talking about taking action in the affirmative. Once it is voluntarily undertaken, it must be performed with due care. But you have alleged that they didn't take the action you requested. So they're not taking that action. So they don't have a duty to perform it with due care. They have no duty. Kevin Cartilage says, given the state of the LoLsuit, is Mental Jest stuck between a cuck and a hard place? Oh my God. Yes. Especially because, as I assume Mental Jess is the breadwinner of the family unit, whatever that looks like in the Maddox apartment hold, then I assume that she will be bearing the brunt of the costs when damages are awarded to all of the defendants. And remember, she is a plaintiff and has set herself up to undertake those costs. I am drinking that 25-year... whatchamacallit? Dalwhinnie. 25-year Dalwhinnie, limited edition, right here. And then I'm having just a little bit because my first glass was tainted a bit by the Balmore. Get you some George Dickel rye. Clam you down a bit per se. I'll try some. I've heard the Dickel rye is good. I also need to get some Masterson bourbon. But let's see. While there is no contractual relationship between plaintiff and Weber Shandwick does have a contractual relationship with Kaufman and Kokonos, respectively. Yeah. See Landon versus Kroll Lab Spec Incorporated. Although the existence of a contractual relationship by itself generally is not a source of tort liability to third parties, the Court of Appeals has recognized that there are certain circumstances where a duty of care is assumed to certain individuals outside the contract. As relevant here, such a duty may arise, quote, where the contracting party, in failing to exercise reasonable care in the performance of its duties, launches a force or instrument of harm. But they didn't launch a force or instrument of harm. This principle... You failed. You were still on. But they didn't launch a force or instrument of harm. Your allegation is that they failed to prevent something that was told to them. So they certainly didn't launch a force or instrument of harm. Their actions didn't cause the alleged abuse, or their inaction didn't cause the alleged abuse. It maybe caused a prolonging of the alleged abuse, which isn't... Can you talk about your love of yams for a moment?
Oh, no, I was looking at that.
She tried to crawl. You're dead. She's dead. She's bleeding right now.
Really wanted my
Okay.
frickin' chicken.
This principle recognizes that the duty to avoid harm to others is distinct from the contractual duty of performance. Yeah, it is, but we're not no one's talking about performance here, so I don't know why you're citing this case, and I'm sure Weber Shandwick doesn't either, and the judge won't either, because this case has no relevance to this, because you're talking about third-party liability based on contracts, and that's usually not an employment contract. Hans Allen says, stay on point, Nick. We need you to explain this to us. And Lady Racket's no more babies for 1 week. She is. She's devastated. She was going for chicken. I think at this point, it's important to point out that due to LanDUI's massive access to yams, he does not have the cold weather advantage, and he is really unable to formulate arguments that contemplate future actions because he never had to plan for the loss of food. His yams and access to large mammals gave him a distinct food advantage, but put him behind in the cognitive development categories. That was for you, Anthony. With these principles in mind, in their complaint, plaintiffs alleged in pertinent part that, oh gosh, they're quoting their complaint again. I'm not sure if LanDUI understands that complaints are not facts. Like they're allegations. based on information and belief that the plaintiff or the affiant affirms to be true to the best of their knowledge. These are not settled facts, and they're not settled matters of law. Contradicting facts in an answer or simply pointing out the wrongness of these facts in the defense has to be considered. Legally speaking, chicken is delicious. I 100% agree. So I'm not going to read these. These are pointless. In Landon, the Court of Appeals held that the defendant, a testing laboratory, didn't get that. That changed the way I sound. That was creepy. Get out of here.
I was trying to advertise Cane's.
She's advertising Cane's.
It was not working.
In Landon, the Court of Appeals held that the defendant, a testing laboratory, did not exercise reasonable care in the testing of the plaintiff's biological sample when it failed to adhere to professionally accepted testing standards and consequently release a report finding that the plaintiff had tested positive for THC. I mean, what is he talking about? Also, you said duty a lot, Keck. Yes. I did say duty a lot. I did. Guys, he's talking about a professional laboratory failing to adhere to the standards of their profession. The only person failing to adhere to the standards of their profession so far is LanDUI. Weber Shandwick, I don't think there's a standard in PR firms, a professional standard list that they have violated. If there is, you'd think LanDUI would have provided the citation and alleged the violation, but he hasn't. He hasn't. The court found that the alleged harm to the plaintiff was not remote or attenuated because it was the plaintiff's own biological specimen, quote, that was the sole subject of this testing, and the plaintiff was directly harmed by the positive test result causing the extension of his probation and the necessity of having to defend himself in the attendant court proceedings. Yes, a lab failing to follow proper procedures in a criminal case causes damage to someone. Them disagreeing with your demand to fire Asterios is not even in the same ballpark. It's not the same sport, right? Further, the Court of Appeals found that the laboratory was in the best position to prevent the false positive results and therefore owed a duty to the test subject that was not immunized through its contract with the county. The principle demonstrated in Landon has been applied in a variety of circumstances and cases. For instance, in Bynum versus Keber, the allegation from a mother of a music festival attendee who ingested harmful substances and sustained significant injuries at the festival that the festival promoters knew or should have known of widespread presence and use of illegal drugs at the festival was sufficient to support cause of action for negligence based on failure to exercise reasonable care to curtail the use of illegal drugs on festival grounds. That's probably because it was in their lease agreement to prevent the use of illegal drugs on the grounds. That's a standard provision in pretty much any land or real property rental lease agreement that you cannot engage in illegal activity that amounts to a breach of contract and may result in further liability. You can't just... Guys, the level of incompetence occurring at this point is frustrating. The scope of the duty in Bynum was defined as according to the likelihood that such behavior will occur and endanger attendees based on past experience. In the instant case, the scope of Weber Shandwick's duty was defined based on the notice that they were provided by Mr. Powell Stroud. Oh, yes. Yes, a known internet troll. The type of person that you're alleging Asterios to be. That if Weber Shandwick is the internet troll expert that you call them out to be, would know exactly who he is, and when they looked into him at all, would see that his statements are hypocritical at best, if not outright falsehoods, probably doesn't give any credence to them. And Mr. Orangutan, another known internet troll, self-described one of the most popular internet trolls that they are. That there is, right? According to him. And again, and they didn't know it was Mr. Orangutan because Mr. Orangutan falsely impersonated a different person. And he did it so poorly that I'm sure they knew it wasn't them. but we're going to discuss that later. I have to hold off on that. Why are they always called instant case? The instant case just means the current case as distinguished from cases that have been cited in the document. So it's just a way to delineate between the case that the judge or clerk or other party is looking at right now from the citations and references that are in the document. You make it, Nick. You almost hit cuck bottom of the LoLsuit. Relative to Kokonos' conduct, and because there was a strong likelihood that such behavior would occur and endanger plaintiffs or others based on past experience and the business that Weber Shandwick is in. They have no past experience that Asterios' actions would cause any harm to anybody, because as far as we know, Asterios' actions haven't caused any actual harm to anybody, even to the present. You failed to allege that or properly allege that you've received harm from his actions currently, much less anyone in the past. Weber Shandwick is intimately familiar with online harassment and trolling, and even hosts an annual event called Civility in America, which is supposed to be about their company working towards making America more civil. Ironic, then, that someone like Jesse Powell Stroud and Maddox Orangutan would go to Weber Shandwick and demand civility, which is supposed to be about their company working towards making America more civil. Oh, I just read that. Is it civil to falsely accuse someone of being a rape apologist and falsely allege that they created a rape list and then go ahead and spread that to every business contact that they have in the hopes that they would lose their business contacts and lose their contracts? That doesn't seem very civil, especially when it's based on a lie or a distortion. And it seems even less civil when you bring up the fact that you play tested those videos and created 4 different edits to create the most damaging one possible amongst your peer group. That's pretty scummy of you. How's that for irony? Further, Weber Shandwick has a Top of the Trolls campaign, and clients of Weber Shandwick spend hundreds of thousands of dollars on proprietary social media crisis simulator entitled Fireball. I wonder who's on the Top of the Trolls campaign. Does anybody in the chat want to look up the Top of the Trolls campaign and see if there's any information about who is on top? That'd be interesting. This website describes how Fireball works. Maddox is salivating every time he reads this document, and guides potential clients through the various phases of a real-time online attack of their brand or organization on a secure, controlled environment. I think they're misunderstanding where that attack is coming from. One section on this page is entitled The Cost of Complacency, where Weber Shandwick states how disastrous online harassment and social media can be to a potential client's reputation, profits, and growth. Okay. Sarah Marie, you are good. You are good. Driven by real-time social conversation, crises are costly to your reputation, profits, and growth. The vulnerability today is not limited to obvious catastrophes or unobvious apostrophes, such as a plant explosion or product recall. Rather, social media makes a crisis out of an innocent photo taken by an employee, a careless tweet from an executive, or a falsehood posted on Facebook by someone with an axe to grind or 5 minutes to kill. Maddox, Jesse, LanDUI, all 3 of you, read the stupid sentence that you just quoted from Weber. You're trying to do what Weber is trying to prevent. This isn't helping your case. Javier Maedo says, get the missus to read a page or paragraph you'll skip. They want you to read.
I don't like to read.
Theresa May is on top. So ridiculous that the things they are referencing is literally just them. I know. It's absolutely infuriating. Further, Weber Shandwick has their own definition of internet trolls, as you've said a million times, as people who deliberately post argumentative or proactive content. Therefore, Weber Shandwick knew or should have. Guys, Weber Shandwick knew or should have. That's it. They knew or should have. Not only was Weber Shandwick notified that Kokonos was engaged in such behavior from multiple sources, both liars, with specific examples, but a large part of their business is to prevent that very thing from happening to its clients. No. A large part of their business is to prevent what you did from happening to their clients. What you were trying to do to Weber Shandwick. That's what they're trying to prevent. You dense pile of garbage. Accordingly, under New York law, plaintiffs have adequately stated a cause of action for negligence based on Weber Shandwick and Kaufman's. Why do you have a comma there? Failure to exercise reasonable care in response to plaintiffs and other complaints. No apostrophe necessary. Nicholas Allen, remember The Game? Are you talking about the Michael Douglas movie, The Game? Or the book, The Game? Similarly, Weber Shandwick's... Okay. Someone please tell me I'm wrong. But if you abbreviate... there should be an S after the apostrophe on Weber Shandwick. On the abbreviation of Weber Shandwick. There just should. And you can try and argue with me all you want. You're incorrect. There should be an S following that apostrophe. Negligence extends to its complete failure to eliminate the use of its equipment and technology in perpetrating an online harassment campaign by Kokonos, an employee. I think he means the cerebral assassin, The Game, Triple H. Oh my goodness. In Landon, the court found that the defendant had a duty to the test subject to perform his drug test, quote, in keeping with relevant professional standards. Certainly, Weber Shandwick's response in the instant case to this ongoing social media crisis was not in keeping with relevant professional standards. Were you paying Weber Shandwick? You're trying to leech their actual business. You're trying to say that you are demanding the service that they charge, quote, hundreds of thousands of dollars for, to you for free. You want their crisis management for free. Gosh, which they always held themselves as being a champion combatant of the same. For profit. For profit. I know economics is hard for you, Maddox. I know that it is extremely difficult for you to fathom that companies charge money to things because you have so repeatedly failed to understand how to monetize your own success. I get it, buddy. But you got, go back and take an economics class and listen. Pro writer with an English degree here. Yes, there should be an S after the WS apostrophe. Thank you, Mike Leon. I am also a pro writer with an English degree. Mad props, buddy. Amazing how Landau keeps finding new places on this dead horse to beat. LanDUI's wrestler name should be The Shame, the Inebrial Disaster. All right. Okay, let's see. Given that the instant case involves social media and online harassment, there is not a substantial body of case law on the subject. However, there have been cases recently decided where courts in New York stop putting all these commas in, have imposed liability for negligence and consumer protection under far less egregious circumstances than the instant matter. Normally for data breaches. See, Pharaoh versus Excellus health plan. I wish my moderator was in the chat because she has been studying data breaches and cybersecurity and would probably, well, I guess I'm glad she's not in the chat because she probably would have died at that statement. Where allegations of insurance subscribers that healthcare providers and insurers failed to safeguard their personal information, and as a direct result, hackers gained access to their personal information in cyber attack, leading to identity theft and fraud, plausibly alleged that their injuries were fairly traceable to the data breach. Guys, this dummy just stated that loss of your identity, your protected identity information due to a data breach is less egregious than what has happened to Maddox as a result of Weber Shandwick not firing Asterios Kokonos. That is the level of hubris arrogance and narcissism at play here. That a data breach leading to actual identity theft is less egregious than Maddox being made fun of online. Ever thought of going on the morning Kumite or Andy Worski with Mr. Medicare to go over this stupid stuff? They hate Maddox as much as all of us. I'm open to going on any show. You know, I've not made proactive contacts with very many people, but, you know. Oh, and by the way, hack the planet. Let's see. Further, the provider's failure to disclose purportedly inadequate data security measures would mislead a reasonable consumer, which was sufficient to support claims prohibiting deceptive acts and practices, GBL 349. Yeah, it is, because there are also cybersecurity regulations that were actually breached by their negligent failure to properly secure the data of their clients. Shockingly, there are statutes which regulate online companies and how they collect and keep and secure data. And if you breach that and then in violation of a statute, that leads to GBL 349, because GBL 349 is basically any failure to, as a business, to abide by relevant statutes. Alan Foster, you're welcome on my show whenever you want, fam. Sounds good, buddy. You'll have to get me on there. Let me know. Seriously, message me. We'll talk about it. Someone on the IRC said that at least 2 Heather S's have been found at Condé Nast. Would that change anything about Maddox pretending to be someone else? I don't know. I've only seen one, and we're going to talk about that in a little bit, although I believe I have properly redacted everything on this one. When do you think LanDUI 2 Drunken Electric Boogaloo will be? Sooner, later? It depends on how next week goes. Some of it's going to be tonight. Watch out who you associate with. It's only a matter of time before you're labeled alt-right. I'm sure someone has labeled me alt-right for the Google videos because they don't know what alt-right means anymore. Who really knows what alt-right means anymore? Okay. CNRE Experian data breach. Motion to dismiss negligence claims under New York law was denied. Claim involved a data breach, and one of the plaintiffs spending approximately 3 hours addressing issues arising from the data breach. Yeah, because taking care of identity theft is difficult. Alt-YAM. Alt-YAM is probably the more nefarious wing of the alt-right. Employees of a hospital stole patients' personal information and sold it to third parties who used the information to open fraudulent credit cards accounts, make fraudulent purchases, and fraudulently obtain income tax returns, sufficient to state a negligence claim against the facilities. Again, he is citing these as less egregious than what has happened to Maddox. Evidence that bank failed to establish and maintain adequate supervisory controls to assure that its own rules and the law were not violated, supporting the finding that bank was directly negligent. Plaintiff stated a cause of action for negligent infliction of emotional distress against defendants Weber Shanwick and Joshua Kaufman. There shouldn't be an apostrophe after defendants. I don't know how you can be this bad at apostrophes. So let me have a brief sidebar about negligent infliction of emotional distress. This is an absurdly difficult claim. This is an absurdly difficult claim to make in tort law, to win. Infliction of emotional distress, you have to show actual emotional damage. It has to be... Let me give you a hint of what is intentional infliction of emotional distress and negligent infliction. They're the same type of scenario. Imagine you have a family with children, and someone comes up and grabs one of your children and points a gun at the child's head in front of you and says, "I'm going to kill your child." That is intentional infliction of emotional distress. That is the type of harm that we're talking about. Because if they're threatening you, it's an assault. That's not infliction of emotional distress. Emotional distress in these types of cases is a instant, proximate threat to someone else which causes you distress, typically. I mean, there's some other scenarios. Another thing would be like if you're walking in a crosswalk with your family, okay, and your kids are in front of you and someone blows through a red light and hits your kids right in front of you. That would be a negligent infliction of emotional distress, because you have to watch severe injury or threat to to someone near you, physically close. That's how that claim works. This is what they're alleging. This is a really difficult claim to make, and especially when it's just someone being made fun of on the internet who doesn't even allege that they've gone to therapy and doesn't even produce any sort of documentation or opinions from any sort of professionals that they have actually been affected by these events. Yeah, but what if he committed blasphemy by referring to Pontiff by name? As an initial matter, the case that defendants rely on, Kenneth S. versus Berkshire Farmer, is a third department case, not a first department case. Further, defendants' reliance on Kenneth S. is misplaced. Under New York law, extreme and outrageous conduct is not an essential element of a cause of action to recover damages for negligent infliction of emotional distress, and a breach of a duty of care resulting directly in emotional harm is compensable, even though no physical injury occurred. Yeah, but it's not that physical injury occurs. It's at the threat of the injury, whether physical or monetary or mental, the threat of the injury is so terrifying to the person witnessing it that it puts them in physical distress, usually manifesting in like time off of work, needing to go see a mental health care professional, perhaps needing medication and therapy to compensate for what they have witnessed. However, the mental injury must be a direct rather than consequential result of the breach, and the claim must possess some guarantee of genuineness. You've defeated your own claim right there. How long until they claimed they were emotionally distressed by Dick's association with infamous school shooter and terrorist Sam Hyde? Also, I was going to ask, how can he keep getting away with it? I mean, at this point in time, we have to assume that Sam Hyde is part of the deep state. I see you shaking your head as if the error in what's being said should be super obvious, but the reason we listen is because you make what seem obvious to you known. I know, I'm shaking my head because it should be obvious to LanDUI. Sorry, is there any merit in identifying third department versus first department? I mean, technically, the different departments would be like different judicial districts in my state, okay? In my state, we have various judicial districts. I'm in the 8th Judicial District, is the county where I typically practice. So something in this case, in the first department, would be more authoritative than something in the third department. But it doesn't mean it's not authoritative. It'd be like if a 9th Circuit Court was citing a 4th Circuit Court decision. A 9th Circuit Court decision that it would cite would be better, but a 4th Circuit Court decision would be informative. I'm not 100% sure how the authority delineation works between first and third departments in New York State, but they're still state courts. So state court decisions, whether or not they're in the same department, definitely have weight and bearing, and especially if they're relevant to the case. If nothing else, it's a guide to the court to say, how are we ruling consistently with other districts? And if we're not ruling consistently, are we ready to assert that the other district is wrong to the point where an appeal would decide the difference between our two decisions? So, sorry if I didn't can you take time off of being unemployed? Sorry if I wasn't clear before, FSPAMSS. But LanDUI should know that unless there's a better example out there, it's perfectly reasonable to cite a third department case in a first department, action. Okay. So in the instant case as set forth more fully above, Weber, Shamwick, and Joshua Kaufman breached a duty owed to plaintiffs, but they don't owe the duty which unreasonably endangered plaintiffs' physical safety. Okay, the reason that is funny to me and also why it is stupid is because their physical safety has never been shown to be endangered. Endangerment of physical safety requires a reasonable assumption that physical harm is imminently about to occur. Not that it is in some scope of possibility that it may occur, but that it is about to occur. So a mob of people outside your door bashing it down, saying we're going to kill you, imminent physical safety threat. Someone on the internet saying kill yourself via cinder block, not imminent, not a threat, imminent threat to physical safety. Or cause plaintiffs to fear for their own safety. That fear has to be reasonable. Has to be reasonable. Maddox is a longtime internet professional, and he should know that basically none of the threats that he received, if you can even classify them as threats, and certainly not anything done by Asterios or Dick, would put anyone in reasonable fear for their actual safety. Would this EED apply to a husband who comes home to his wife in bed with the pool boy in the context of a non-cuckold? Possibly. That's an interesting question. I'd have to do more research to talk about it with some authority, but I think that's actually a pretty good example of something that could reasonably be infliction of emotional distress. Alan Foster says that you guys need to throw me a super chat because he's broke and can't do it right now. I appreciate that, Alan. Yeah, if you guys want to send me a super chat, that's great. But again, I don't require that. I will talk if you tag me. I do a lot of this for fun. I love when you guys give me money, but this is also fun for me. So
He tells me that too.
LanDUI thinks you suck and cites Paul's Graph versus Lear as relevant case law. Okay. Do you think you would do a better job than Jeff Sessions? Yeah, I do a better job than just about anybody, in my own opinion. And that's not narcissism. That's just that's more of a disdain for other people's ability. Rather than some ill-fated faith in my own, I would consider myself barely competent to their incompetence. It wasn't to kill themselves with a cinder block. It was to increase the mineral content in their diet by consuming the aforementioned cinder block. I guess they should eat some iron too, right? All right. Contained in the emails sent to Mr. Kaufman, among other vile things, were threats of rape and death and appalling racism, not from the defendants, you dumb people, against plaintiff Jessica Irene Blum, which were either made or encouraged by defendant. They weren't made by defendant Kokonos. They certainly were not made by him, and they were not encouraged unless you really stretch the definition of encouraged, but they weren't. And his followers, some of which used their real names and led to their prompt identification. What, really? Did they? Where have you identified them? Like, actually, and why didn't you call the police against them? Weber Shandwick could have immediately put a stop to this vitriol, but elected not to. Okay, here he goes citing his own complaint again. And he actually cites his complaint so much that he refers to it as id, without a proper italic. You guys, he should be sanctioned for that. JLH, you're back in Texas? That's interesting. Accordingly, plaintiffs have stated a cause of action for negligent infliction of emotional distress under New York law. See Johnson v. State of New York. Let's see. See Kennedy versus McKesson Company. The defendants were I skipped Johnson. Where state hospital negligently misinformed daughter of patient that her mother had died. The defendants were negligent in replacing color-coded decals on machine, resulting in death of patient. As a result, dentist's mental condition was such that he was unable to carry on professional work, and damage to his reputation, was obliged to withdraw from practice, stated valid cause of action. Yes, a dentist who was unable, due to his mental condition and mental state, to continue on his professional responsibilities as a dentist and damaged his reputation, had to withdraw from practice, is a little bit different than an online complainer who still online complains just to a smaller audience because no one is interested now that they know it's not a joke. Wow. Well, JLH, if you're back where you were living in the same town, we've got a family reunion down there. Sometime in June, I think, that we'll be down. We should get some Stanleys. Lady Rackets just went, Further, the Court of Appeals has allowed recovery for negligent infliction of emotional distress under the direct duty theory in a case where defendant's duty may not have been directly owed to a specific plaintiff, such as Plaintiff Blum here. They didn't... Oh, I'm saying... I see. They're saying that they didn't owe a duty to Plaintiff Blum. Yeah. The holding in Orenstein establishes an exception to the direct duty theory by recognizing that a duty specific to a targeted group of individuals within a population, such as nurses in a hospital, so such as trade show models, I guess... is sufficient to establish a direct duty to one such individual, such as Plaintiff Jessica Irene Blum here. What class are you alleging her to be in? You are, for now. For how long? In June? Will you be there in June? If so, we definitely need to meet up. It won't be so cold, and I can stand outside and talk to you. Although it will be hot, so that could be another problem. Conclusion relief requested for the foregoing reasons. Plaintiffs respectfully submit the defendant's motion to dismiss pursuant to CPLR 3211A1 and 7 must be denied in its entirety. To the extent that any part of defendant's motion is granted, plaintiffs request leave to replead pursuant to CPLR 3211E and CPLR 3025. That should be immediately denied, but Weber Shandwick is going to have a field day with this dumpster fire. Wow. I honestly am giddy to read Weber Shandwick's response because they're going to rip this apart. Oh. Did he spell his own name wrong in this one? Doesn't look like it. Trade show moddies with herpes. Have you missed it all? No, Wolf Badger. You have missed just the end. Get your feet up. You've missed just the end of the document that we started last night. Now we're going to move on to some different things. Yes, this ramshackle affair. Ramshackle affair asks, are those signatures usually stamps? Yeah, they can be stamps. Most of my signatures are just like /s/ because we... Oh, you're in North Austin? I think North Austin... I think we're going to be in Austin some part of the time. Are we? Or maybe we'll pass through. I don't know. I don't remember. The signature block is, it can be a stamp. It doesn't really matter. Foot rape occurred. I saw it. Ooh. Ooh.
He could
Did you read Dax's comment or something?
Oh, no.
Oh.
No, I just saw the foot raped.
Oh. All right.
Gross.
So let's talk about something here. Let's talk about this this Gmail account, hkps1812@gmail.com. Okay.
It's all right. It's safe because I'm wearing my socks.
But Jamie, North Austin, you said? I'll message you when we're going to be down in Texas, and I'll let you know what our itinerary is. Same with you, Hat Buckles, and we'll see. Yeah, I thought Road Rage is in Austin.
What?
Lady Rackets, read my comment right at Rekieta Law.
Oh, I read it.
Don't boop him in the nose with your foot. Likely to break her foot.
Yeah, have you seen that thing?
Okay, so let's look at these. We're not going to look at the substance of these emails because we've covered them before, right? These have been covered, and so I don't want to... Well, we'll cover a little bit, but not all of it. My name is Heather. What? Love you, Lady Rackets.
He's lying. She.
Dax, Lady Rackets was a little bit miffed that you wanted us to stop singing last night, so... I'm not sure she believes you at this point.
Favorite shows you.
Is there a date on Road Rage Texas, by the way, in the chat, if anyone has that? Does the size of your nose inspire confidence in your clients? Absolutely. Absolutely.
How do you own a show?
What, own a show?
What does he mean by that?
Lady Rackets, what are your favorite shows you own?
Dax, we have 5 kids. How can we not do Disney? Come on now.
May for the show, huh? Hopefully not the end of May. We'll have to see what we can do. We'll have to see what we can do on that. But
You sing real pretty. Wait,
you
what?
should read the Heather emails in a woman's voice. You should read the Heather emails.
I don't like. No, I'm a woman. You know I can't read.
The homeschooler of my children, folks.
Shoes? Favorite shoes I own?
Shoes, yes. What are your favorite shoes? They're asking what your shoes like.
What am I?
Music of the Night from Phantom.
The fake uterus, it doesn't work. Mine works. Actually, no, that's a whole other story. We'll talk about that.
Okay, you've got to just read like this paragraph.
Which the my name is?
Yeah. But do it as an incompetent Armenian internet personality pretending to be a woman.
I can't speak Armenian.
Well, I'm sorry that you fell asleep, Mr. Kill Everything.
What?
He fell asleep during our singing.
Jack? What? Who did?
Mr. Kill Everything.
Who's Mr. Kill Everything?
Well,
That just means, you know what that means? You know what? I just read my daughters a book and they fell asleep too. So that's a compliment. I like that. Thank you. That
Okay.
means it was soothing.
Read the paragraph.
All right. My name is Heather. I'm a freelance journalist writing on behalf of the
Condé Nast.
Condé Nast Media Group, whose work has appeared in Wired, Jezebel, and Mercury News, Vice News, etc. In light of Milo Yiannopoulos scandal, shouldn't it be his scandal?
It'd be in light of the Milo Yiannopoulos scandal.
We're doing a piece about online trolls, bullying, and harassment. One of your writers, Asterios Kokonos, is taking part in an online harassment and bullying campaign targeting individuals.
There you go. There you go.
There you go.
All right. So here's the thing. If you want to take a look down here, we're going to get down. We're going to skip most of the content. Thank you, Heather S. Here's a phone number. And I will note that that phone number is a legitimate phone number for Condé Nast. So they are actually pretending to be Heather S. from Condé Nast. I don't know if that phone number is specific to Heather S. I would doubt it. I would think that it's probably a general line. I have not called it. That's not my job. I don't really care. I don't advocate people calling and bothering Condé Nast either. But I want to go to something here. Here is the LinkedIn profile of Heather S. And I have redacted the final part of their last name. And I've redacted down here the place where Heather S. attended university. And I have redacted most of the face, but I have left some of the image so you can see, I didn't just find something with a black circle. There's actually a person's face there. So this is a person in the New York City area. They're a senior producer at Condé Nast. They have 23 stories, or senior producer of 23 Stories, which is a subsidiary or a service, creative, and production company agency within Condé Nast. So a subsidiary of Condé Nast. And they work with all of Condé Nast brands to create custom digital advertising on behalf of the world's most premium advertisers. This is the point that I'm going to... Oh, and by the way, you can see that this is my LinkedIn that I've looked this up on. So, Heather S., if you're watching, that's why I looked up your profile. I'm not actually looking to hire you. Kevin Cartilage says, Nick, if you actually arrange a mini Texas meetup, I'll buy you some expensive whiskey. We'll see. I don't know. I'll let you guys know when I'll be down there, and we'll try and get the word out to everybody and see if we can put together a date. Digital blackface. Rekieta Law strikes again. I'm about to read The Common Law by Oliver Wendell Holmes. What do you think about the book? Is it any good? Did you have to read it for law school? Is it a good introduction to law? I think nothing about the book. I have no idea if it's any good. I did not have to read it for law school, and I have not read it since. I couldn't tell you if it's a good introduction to law. I apologize. But, you know, Oliver Wendell Holmes, famous lawyer, and you should, I mean, it's probably competent work. I don't know if it'll be exciting or not, and I don't know what you'll get out of it, but let me know. Do a review for me. And by do a review, I mean just tell me how it is. I admit it. I'm Heather S. Maddox paid me mad bucks to have coitus with Jessica as long as I emailed Weber's sandwich. But now, so are you, Desi, this is a huge allegation. Are you alleging that Maddox lied about being Heather S. In his most recent affidavit? Because, I mean, the lies, where do they even stop and where do they begin? I don't know at this point. But does Heather S. work at 4 Times Square? Yeah. The competence abounds in Maddox's inability to properly spell Times Square, and without having the accent aigu above the E on Condé Nast. You know, I don't even know. Please post the stream countdown earlier next time. I missed an hour of the stream. I am sorry, buddy. I was traveling. I was a Article 4 free inhabitant. I was traveling today. I was not driving. You can't pin any crimes on me as I was not driving. But I was free inhabitant traveling today, and I was not able to actually get the stream countdown going as early as I thought. But I apologize for that. Please forgive me. There's another Heather S. that works for Condé Nast Traveler. The Condé Nast Traveler Heather S. that I saw worked for Condé Nast and no longer does. Stopped working there in 2009. So if it's the same person, that is why I did not bring them up, because their LinkedIn profile said that they stopped working there in 2009. But if you have someone else, you can certainly send me a message. But let's talk about what this means and why I'm focusing on this. My Alexa is talking. So the first thing that I want to touch on is that Maddox, in admitting that he was Heather S., or at least in currently stating that he is Heather S., whether that's an admission of a true thing or him trying to cover up for someone, is a huge problem in regards to the LoLsuit specifically. Lying to the court in that complaint is grounds for a sanction that would dismiss the action as to at least Asterios and Weber Shandwick, and should dismiss it against everybody. The falsehoods in this case are off the charts. They're really quite offensive, and we're going to look at that after this. But I want to point out that is a sanctionable thing that at the minimum can result in the dismissal against Maddox for perpetrating the falsehood. If it's just Maddox. If it's LanDUI perpetrating the falsehood, LanDUI and Maddox could also be liable for all of the defense's attorney's fees or any portion of the defense's attorney's fees as the judge sees fit. And that is a Rule 11 sanction that would apply to counsel. And I, again, don't advise anyone in this case. If I were one of the attorneys on this case, were I licensed in New York and were I an attorney in this case, I would, the moment he put out that affidavit, all of the defense teams, if I were on any one of them, I would motion for sanctions immediate dismissal of the entire case. I would motion for, because if they lied about this under oath, we don't know what else they lied about. And the fact that they have now come out and tried to rectify that lie. They also, tried to proceed improperly with Metal Jess as anonymous without asking the court. So we know that there are specific things that they are doing that is outside the scope of what should be happening. They should be requesting sanctions for immediate dismissal, and then, of course, requesting sanctions for attorney's fees as well. Pony Cordero says, I mixed my first old-fashioned from scratch tonight. If it's good, I'll call it a Rekieta. If it's bad, I'll call it a LanDUI. Fish Munster, what's your estimate on cumulative defendant's fees? I don't know. I would say that right now, they're well in excess of $50,000. Well in excess of $50,000. Hatbuckles, don't get me started. I blame FPS Russia, by the way, for me saying a Springfield Armory Colt 1911. Yeah, it's his fault. So blame FPS Russia. And I do think that I should find the tag and see if it said Colt 1911 on the Springfield Armory 1911 that I bought, because I feel like the tag at the gun store also said that. I'll see if I can find it and prove myself right or wrong. Yeah, let's say that they are well in excess of $50,000 at this point. If you combine all four parties, I would say individually, they're probably pushing $25,000 plus per party. So we could be talking easily $100,000 by the time all of these motions are in and the responses. That is not outside of the realm of possibility in this case. I blame FPS Russia for me having AIDS because he gave it to me through... Whoa! Wow. Strong assertion. It's a little on the sweet side, so I'll call it a Lady Rekieta. FPS Russia is going to jail soon. You work quick. Wait, is FPS Russia actually going to jail? Because I would cover that criminal case. That'd be interesting. What happens if Sadix can't pay, says Meme Dreams. Maddox would have a high burden to show that he can't pay. Because Maddox has alleged over and over that he has significant advertising contracts, that his show is successful. He clearly has some significant income from YouTube. And it's not just him. It would also include Metal Jess. Their wages can probably be levied or garnished. Whatever those wages are, that would be business income, can probably be garnished. The other thing that could happen is they could potentially levy non-protected property from Maddox and Mental Jess's possession. So what a levy of non-protected property looks like is there's some property that you can't take from someone, like their primary residence. If they only have a home, their homestead, you can't take that from them. Maddox doesn't own a home, so that's not an issue for him. I assume Jess doesn't own a home either. I believe they're both renting as roommates along with 25 other hippies. Not positive, but I think that's how it goes. So if they don't own a home, there's no protection there. Generally, one automobile is protected. I'm pretty sure, I don't think Maddox owns an automobile. He's an avid bike enthusiast. We know LanDUI doesn't own an automobile. Just kidding. I think he owns a Lexus. He just can't drive it. But if they have one automobile that they use for work purposes and transportation, they cannot levy that technically. But just about anything else outside of like food and necessary appliances within the home is leviable under many state statutes. I have not looked up the California collection statutes, so I don't know. I don't know what they could do in California. I don't know what they could do in New York. But I do believe, on information and belief, that Maddox's brands are not protected materials. Any copyright or trademark claims, even if they're just generalized trademark claims. So what I think is a possibility is that Dick could demand ownership, full ownership of the biggest problem in the universe. I think Dick could potentially try and take the Maddox trademark, or not just Dick, but any of these people could try and take the Maddox trademark or any of the claimed marks he has in the universe, maybe his webpage, any merchandise he may have, that might be takeable. Money that he makes from YouTube or any sort of ownership of his YouTube channel might be worth something. I don't know. But these types of intangible properties, intellectual properties, are potentially on the chopping block for the levy. I don't want to get anyone's hopes up. I don't know that this would happen. But these types of things are certainly within the realm of we should ask the question on whether we can take this. So who knows? But this first requires a judge to order Maddox to pay, and then Maddox to assert that he cannot pay. Do lawyers typically give refunds when they lose cases as bad as this one will be? Only if they're sued successfully for it. So I guess Maddox could hire pretty much any attorney. Does a computer count as a necessity? Could they levy Maddox's computer and game consoles? Very possibly. They wouldn't be worth much just because of the way those things depreciate, but that's possible. How about his throne and crowns? Oh, that'd be hilarious. Give the Maddox brand to Mad Cucks. That would be good. That would be good. So, let's see. Jeff M. Why does Maddox keep shooting himself in the face? I honestly think that he has some sort of, I don't know, inability to associate with reality in the way that a reasonable person does. However that can be interpreted. I don't want to come out and say he has a mental illness because I don't want to make some sort of false statement about his mental illness. I have no information about his actual mental health other than just his demonstrated actions seem to indicate that he has a disconnect with reality. That disconnect prevents him from understanding certain things. And this is evident all throughout Biggest Problem. Starting with like the broken window fallacy, that's more of an economics point. But then when he went into that homeowners association argument, it was clear that he thought a small version of government was literally a small version, like a logistically small version of government. So he does not, I don't want to say he's autistic. I don't want to offend autistic people, but he demonstrates some of the traits where they have an inability to maybe detect nuance or certain social cues. Dick has hinted at this as well, that he's difficult to work with for some of these similar things. I think I might be making that up, but I'm pretty sure Dick said something like that, unless it would damage him. Then he didn't say anything like that. But, so I think he's genuinely trying to do the smart or correct or strategically sound thing. He just has no idea what that is. Would you take the case against LanDUI? I could not take that case. I am not licensed in New York or California. It'd be worth it just to inflict emotional damages. If Maddox wins, can the court order 80's girl back to him? I would assume that he thinks that, maybe because he thinks that people can be owned. Considering how much of a financial burden all of LanDUI's work thus far would be on Maddox, do you think it's possible LanDUI has taken the case on contingency? I think it's likely that LanDUI has taken the case on contingency, but I think that he probably has also demanded an upfront retainer to pay for, the cost of proceeding with this lawsuit, because it's got to be expensive. I allege that the defendant's fees could be approaching $100,000 or more at this point. You have to imagine that Landau's fees are approaching the $50,000 mark at this point, because he has to do the work, the same work as 4 of these different people. Now he's copy and pasting a lot of stuff clearly and referencing his own complaints. So some of it, even though he's producing 30-page documents, is recycled and doesn't take as much time. Yeah, I re-listened to that episode. At first, it almost comes off as a joke. Once you get about halfway in, it becomes obvious that he's not trolling. Yeah, that's how most of the Biggest Problem went with Maddox. Works on contingency, no money down. I doubt he works no money down. I really do doubt it. But maybe he does. So anyway, the reason I bring up these emails that I brought up, 20 minutes ago, is this. So this is, I brought up on the last video, criminal impersonation in the second degree. This is the New York statute, criminal impersonation in the second degree. Nicholas Allen says, I am Sofa King We Todd did. Just kidding, you're amazing. Thanks, buddy. Jack Mehoff asks, is there any chance that LanDUI is working pro bono? Are there disclosure requirements if he is? I'm not familiar with New York's pro bono disclosure requirements. I guess there's a possibility he's working pro bono, but I don't think so. This would not be the type of pro bono case most people would do, unless he has a specific relationship with Maddox outside of their, that pre-existed the representation. He's representing him as a friend or a fan or something like that. He could be working pro bono, but we won't know. How likely do you think it is for LanDUI to come out of this with a ramshackle career intact? I mean, his career is, if it's not done in already, I don't think this will do it in. Dax does, what grammar? Look at the grammar. What grammar? Okay. Would have LanDUI agreed to take Maddox's case if he paid off the counselor's outstanding bar tabs around town? Oh, that's brutal. Yeah, I'm sure he loves you too. Pro bono. Hello and good morning. This be Bono. I do miss Bono. Okay, let's get into this. Sorry. Criminal impersonation in the second degree, if you remember, is under New York law definition, impersonation of someone for the purposes of gaining a benefit or causing injury to someone else. So I have pulled up the 44 major decisions that Westlaw has on this. We're not going to go through all of them, but I want to give you an idea of what criminal impersonation in the second degree actually looks like. So the construction and application. Although terms injure and benefit as used in the statute providing that a person is guilty of criminal impersonation in the second degree, when he or she impersonates another person and doesn't act in such assumed character with the intent to obtain a benefit or to injure or defraud another, cannot be construed to apply to just any injury or benefit, no matter how slight. Injury to reputation is within the injury contemplated by the statute. So no monetary damages have to occur, no physical injuries, no mental injuries. Injury to reputation is within the statute for the criminal impersonation in the second degree. So if Asterios's, or if Maddox's impersonation of Heather S., an actual person working for Condé Nast, and setting up the email to look like someone from Condé Nast, albeit with spelling errors, if that was intended to cause injury to Asterios's reputation, even just his reputation, if not his full employment, that is within the statute. That's bad for Maddox. I'm drinking Fireball cinnamon whiskey right now. Try to control your jealousy. I'll work really hard on that, Max. Statute providing that person is guilty of criminal impersonation when he impersonates another and doesn't act in such assumed character with intent to injure or defraud another does not prescribe cross-dressing. So that Maddox is dressing up as a woman to do this. That alone is not prescribed by the statute. So you can cross-dress without being guilty of criminal impersonation in the second degree. It's more about the intent of the injury or damage. So elements of the offense generally, and this is probably the only other section I'm going to read because the other stuff gets really nuanced, but this is informative. A person may be found guilty of criminal impersonation in the second degree if he or she impersonates another with the intent to cause a tangible pecuniary injury to another, with the intent to interfere with governmental operations, or with the intent to harm the reputation of another. A pecuniary injury is an economic or monetary injury to someone. So did he try to harm Asterios economically or through monetarily? Yes, he tried to get him fired. Boom. Element of the claim is done. And the other is harm to reputation. So if he or she impersonates another with the intent to cause a tangible pecuniary injury or harm to reputation. I mean, Maddox fits all of the elements of this crime. Defendant's mere act of holding other person's driver's license in apparent preparation for criminal impersonation did not constitute punishable attempt. Defendant cannot be convicted of criminal impersonation without proof that he assumed identity of a real person. We know that Heather S. is a real person working at Condé Nast. In order to sustain a conviction for falsely personating another in violation of former penal law 1909-928, it is necessary to show not only an act of false personation by another by the party charged with the crime, but also there was some act which, if done by the person falsely personated, might result to that person's injury or disadvantage. And it is not essential that the act on the part of the person falsely personating another would necessarily subject the party personated, if doing the same act, to a charge, forfeiture, or penalty, but it is sufficient if the act done, if done by the party personated, might in any event lead to the imposition of a penalty. Okay, That's thick. But, it doesn't have to directly result to the person they're impersonating. Therefore, one who appears and answers in criminal proceeding in which the defendant is charged with disorderly conduct and falsely personates the true defendant therein is guilty of violation of said section. So you can't represent you're the other person in court. You think you might have found a legitimate Springfield Armory Colt 1911 at a place called Oceanfront Gun Shop right on the beach in Arizona? If there is no such person named Heather S. at Condom Nasty, does that throw out criminal impersonation? Potentially, but there is a person named Heather S. at Condom Nasty, so we don't have to worry about it being thrown out. Yes, there's IT Weeb. Yes, there's a real Heather S. Right here. Heather S. You can go back and watch this section, but this is their LinkedIn profile. They work at Condé Nast from 2015 to the present. They're a senior producer. So, yep. Okay. Lady Rackets is going to bed, y'all. So.
Good night, everybody. I'm never going to get used to where the camera is because it feels like it should be on the other side.
It's mirrored.
I know. I hate that. Okay.
Go to bed.
You go to bed. Don't eat my jelly beans.
Just got back from Mamma Mia. How much did I miss? Quite a bit. An hour and a half, buddy. But welcome to the stream. So Maddox is so stupid he couldn't even make a fake name. I think that he...
Max, I forgive you.
I think that they intentionally didn't make a fake name. I think they maybe made a name. They picked a name that I would argue, if I were a prosecutor, that they picked a name with the intent to impersonate that person so that if Weber Shandwick were to look up and see if a Heather S. worked at Condé Nast in some sort of like preliminary surface level vetting, that they would see a Heather S. that worked at Condé Nast. I think that was actually their intent, is to impersonate this person. And trust me, any prosecutor who's got whiff of a crime would take that same assumption. And the evidence here is pretty strong that that's the case. So only 4 more hours left. No, probably not. I don't think we're going to go that much longer tonight. But we'll see. Let's see. Okay, so in this section, providing that a person is guilty of criminal impersonation when he or she impersonates another and does an act in such assumed character with intent to obtain a benefit or to injure or defraud another, the word another means a real person, not just a fictitious or assumed name. So again, there is a real Heather S., and the another being injured can certainly be Asterios Kokkinos. They're real people as far as we can tell. Yeah, gravamen of offensive criminal impersonation is holding oneself out as some other specific individual. I mean, I don't see how the elements of this crime are not met, and the admission is filed under oath in a court document. A prosecutor should take this, and Maddox should probably take a plea deal. But don't take legal advice from me, Maddox. Hire a criminal defense attorney in New York. Can Heather S. choose to pursue charges? So here's an interesting thing about criminal charges. You don't have to pursue anything. The state can pursue the criminal charges. And Heather S. Wouldn't have to do anything about this at all. Heather S. doesn't appear to have actually been involved unless... And this would be like, deep state level conspiracy. And I do not think this has occurred. I have no evidence of this, but it is within the realm of possibility, I guess, that Heather S. would be somehow associated with Maddox, and that Heather S. would have allowed them some sort of, to use her name and initial and given them contact information or something like that. I don't have any information that has happened, but that is within the realm of possibility. And in that case, Heather S. would be involved. That would be the only way I could foresee Heather S. being involved in any of this. But I think the likely outcome is that, Maddox in some way found someone who worked at Condé Nast, named Heather S., and went ahead and picked that so that there would be some preliminary vetting, or thinking there would be preliminary vetting, and they wouldn't look too deeply into it. But would note that there is a real person at Condé Nast. So I think Maddox tips the scales. But you don't need to press charges. The state's job is to press the charges. If a prosecutor believes they have probable cause to bring a criminal charge against someone, they do it. That's what they do. Whether you want them to or not, even as the victim, that can sway a prosecutor, but they don't have to listen to victims. And trust me, they don't. They don't. If they have the evidence to convict, or if they believe they have the evidence to convict, or at least the evidence to get a guilty plea, they'll often make the charge. What if Maddox registered a fake LinkedIn profile and used a fake picture of someone? I mean, I guess that's a possibility. Who knows? If Maddox goes, should Maddox hire Raphael Gallagher? Raph is a prosecutor, so probably not. If Maddox goes to jail, will he be able to bring Jesse P.S. with him as his bottom? I don't know if they let you bring employees in. Okay, as his bottom bitch. There you go. So, I bring this up again. I have no desire or obligation to report any of these crimes to New York. It is not, it's not for me to do. There are people involved in this case who could certainly contact the police about the criminal impersonation. I think I talked yesterday about the affidavit of Jesse Powell Stroud and how that potentially implicates him in 4th-degree stalking against an individual in this lawsuit who could certainly contact law enforcement and make a claim that is happening. These are statements that are filed under oath. It seems like they're pretty easy to prove from a criminal perspective. So there are people affected by this in the real world that can certainly do this if they're interested in pursuing that. Other than that, I don't know. I don't know who else would send this information on to a New York City prosecutor or the New York City prosecutor's office or police, but presumably someone could. But I think the reports of crimes from a third party that they do not know are likely not given much credence. So who knows? But again, I will not be making any reports of these. That is not my job. I'm actually a defense attorney. I would typically, not be reporting crimes to anybody unless I had actual knowledge that a crime was going to be committed imminently, which I don't. I don't have that information, so that's outside of my scope. And I do not advocate specifically anyone doing this, but there are certainly people affected by this who could do it. The number of self-owns in this lawsuit is extraordinary. I agree. Interesting idea. Weber Shandwick did state that there was no one working at Condé Nast named Heather S., if I remember correctly. I don't know if they stated that or not. I don't know. It could be. Could be that they mentioned that. But according to LinkedIn, they're incorrect. And I don't know if there was some, like her, in theory, she could have worked for Condé Nast at some point and no longer works for them and just hasn't updated her LinkedIn profile. And in that case, may have been working at the time of all this stuff a year ago. Who knows? I don't know. I honestly don't know anything about this person, and I really don't want to do anything to drag her into something that she likely had nothing to do with. That seems really awful to do to anybody. All right. Let's see. Why are you cheersing Andrew Gluck? Are whales and dogs usually cohorts? They... in this weird new universe that Landau and Maddox have created where reality doesn't happen, I think so. All right. So here we go, guys. This is the next document. And this is a document that was cited in this case, which is the only reason I bring it up. What are the odds that this case actually gets thrown out because of Maddox's lie? I mean, it's got to. It's got to at this point. It's got to be, it's got to. The lies that are provable by affidavits of the plaintiffs alone are enough to have this case thrown out. And man, they're bad. But let's talk about what these sanctions look like. Could you show me the right way to smell the whiskey before sipping? Yeah, you gotta, this will be great for me. You stick your whole nose in the glass. Take a very deep sniff and give it a moment. Let it sit in there. Take another sniff if you have to. Don't do like this number. That's not. You get yourself in the glass. And I don't really have anything left in here. I'm trying not to drink heavy tonight because last night got pretty good. But I still smell it. There's a drop. That was like a $3 drop of whiskey. But yeah, so get your whole nose in there, smell, take a sip, pause and let it sit on your tongue for a little bit. Let it go under your tongue. Let it hit all of the taste centers of your mouth because you want to be able to identify the different sensations that are there. Then take a swallow, pause a moment, and breathe out through your nose and mouth at the same time. You will thank me for it. No one's got a schnoz like Rekieta Law. Not many people. What are the chances they would take any action? I mean, extraditing him all the way to New York to face the charges seems like it would reduce the chances of them bothering with it. Maddox is going to be in New York, or has alleged that he can be in New York to pursue this lawsuit. So, if he fails to appear, they could, I don't think they're going to put him in jail. It's a misdemeanor offense, as far as I can tell, in New York. So jail time is unlikely, but he's got representation in New York. I think they could charge him, but maybe they should just charge him in California. Meme Dreams. What are the chances that Cuck goes to jail for this? In New York, I don't think the chances are high that he goes to jail. I think it would more than likely be a fine. It would be absolutely embarrassing, and it would cost money for him to defend. So they should do it. Do you need to swirl whiskey around the glass as you would with a good wine? You can, and you can watch the whiskey's legs as it sticks to where the top of the swirl is and slowly comes down. The longer it stays up, typically the older the whiskey is, but you don't have to swirl it around, but you can. No wonder Lady Rackets married you. Is it the nose? He is doing business in New York. That's what he says. If this gets to trial, would it be open to the public? Probably. Not open to recording generally. You typically cannot record in a courtroom, although lots of courtrooms are recorded, and those records could sometimes be purchased from the court after the fact. But yeah, you could probably go watch. Almost guaranteed you could go watch, as long as you are quiet and follow the court's rules of decorum. But let's see. So this is Almaciga versus CIR, Univision, Livesey, and Hooper. This is another LanDUI case, and it was mentioned by Greenberger. And this is, I'm not going to go through this whole document. This is a 65-page opinion for a lawsuit that LanDUI lost. And it's a 65-page opinion mostly because of the sanctions that happened against the plaintiff that LanDUI was representing and that LanDUI himself narrowly avoided. And I want to talk a little bit about these. I want to talk about a little bit about these Rule 11 sanctions. So you can make a Rule 11 motion for sanctions. You are not required to, I don't believe. I believe the court can actually take the Rule 11 sanctions and impose them at the court's discretion without a motion. Gats, we need to get someone in there with Google glasses. Follow-up question, what are the tier rewards? Tier rewards for what? The tier rewards for... Oh, does New York Commercial Court have a Patreon of the live stream? And then what are the tier rewards? Oh, that'd be hilarious. Would playing the Titanic theme be following the rules of the court? You would have to play that on the steps of the courthouse, which should be doable. It's just 65 pages of obscenities. Shill your Patreon. Okay, thank you, Andrew. Yes. Patreon banner is across the top of the stream up here. It is patreon.com/lawsplaining. If you like what I do, come help me embarrass Maddox by beating him even more than I currently am. And also check out the other content I produce. I love doing these LoLsuit videos, but I cover a lot of topics, and my Patreons have a lot of influence over what those topics are. So if you want a specific topic, a specific lawsuit, a legal issue, a congressional issue, a question about constitutional law, a question about counterterrorism law, all sorts of these little hobbies of mine, please come on Patreon, drop me a couple bucks, and tell me what you want to see, and we'll see if we can make it happen. We also do live chats for Patreons in the Discord pretty much every Wednesday, and there are a couple other bonus features too. But come check it out. We have a ton of fun in the Discord, and yeah. If you are a Patreon, you don't have access to the Discord link. I am inept at setting up the bot, although I'm working on it. But message me, and I will get you a Discord link. Dominic Peluso, I have no power at my house for 2 days. What do? I'm surprised you're still alive, because when that happens to me, I pretty much want to kill myself. Isn't there a lawsuit involving frogs or something? Yes, I just did a video on the creator of Pepe versus Alex Jones, and I really like that video. It's only 30 minutes, and it's much more direct and high energy than some of my other videos. So it's a fun one. Go check it out if you want to see what kind of content can be on the stream. Dax, you watch all my videos, and I appreciate that very much, and I love seeing your name in the comment section. So, all right, let's take a look at this document. So, some background on this story. Before the court, let's read this a little bit. Is the motion of Defendant Center for Investigative Reporting. This is the main defendant in this case for judgment on the pleadings, as well as CIR's Rule 11 motion for sanctions against plaintiff Erica Almasiga and her counsel. That would be Kevin Landau. Subsumed within defendant's Rule 11 motion is a Daubert motion to exclude the testimony of plaintiff's handwriting expert. If you don't know, like one of the recent district court nominees of Donald Trump was unable to on the cuff identify a Daubert motion. And guys, not everyone practices, and not everyone practices using expert witness testimony. So the fact that this guy couldn't properly identify a Daubert motion in a congressional hearing when he admittedly hadn't been in a courtroom, maybe ever, or not since law school or something like that, that was a little unfairly held against him, I would say. But, whatever. A Daubert motion is a motion challenging expert testimony, or at least requiring some authentication of the expert's credentials. In this case, the motion was to exclude the testimony of plaintiff's handwriting expert, Wendy Carlson, partly on the grounds that handwriting expertise is not a well-established scientific method and does not have an appropriate peer review process to be regarded as scientific. It is more of a pseudoscience, as stated by this court. I have nothing against handwriting experts personally, and their craft is interesting, but it is not necessarily sufficient in a court of law to proceed as expert testimony. So they moved to dismiss the testimony of the handwriting expert for many deficiencies. But that's what the Daubert motion is for, is challenging that expert testimony. So on March 31st, 2016, the court issued a bottom line order granting CIR's motion for judgment on the pleadings and dismissing the amended complaint with prejudice against all the defendants, including defendants Livesey and Hooper. Livesey and Hooper. This opinion and order explains the reasons for that ruling, addresses CIR's remaining motions, and directs the entry of final judgment. In particular, the court grants defendant's motion to exclude Carlson's, quote, expert testimony, finding that handwriting analysis in general is unlikely to meet the admissibility requirements of Federal Rule of Evidence 702, and that in any event, Ms. Carlson's testimony does not meet those standards. So generally, handwriting analysis is not good enough, and specifically, this particular expert's testimony is not good enough. Additionally, because the court finds that plaintiff has fabricated the critical allegations in her amended complaint, the court imposes sanctions, though because of her impecunious status, she's broke and homeless. I don't know if she's homeless, but she's poor. The sanctions are non-monetary in nature. The court declines, however, to impose sanctions on her counsel, which seems a little innocuous until we get to what exactly he says to counsel. If someone donates $3 more, then you'll make 3 times more than Maddox. So someone go do that, please. That would be great. The handwriting expert I originally used for this case was the owner of expertdocumentexaminer.com. I'm not even joking. He offers bronze, silver, and gold analysis packages. Oh my goodness, guys, there are professional expert witnesses out there. Some of them deserve to be professional expert witnesses and have credibility and ethical standards that they follow. Not all of them do. For example, in a case I was looking at taking, I contacted a forensic genetics expert and presented the case to him that I had and the documents that I had. And he specifically informed me, do not hire me for this case. You'd be wasting your money. That person is in severe trouble. I ended up not taking that case, but I wanted to give credit to that guy who is a expert witness with 20 years of expert testimony experience. And having that expert testimony experience is extremely valuable when you're looking at an expert witness, because they might be very good in their field, but they might be very unlikable in a courtroom. And if you want a popular TV version of this, the show Bones often provided Emily Deschanel as an expert witness in court, but she was routinely regarded as cold or unlikable by the jury, or at least portrayed that way. Although they always ended up winning their cases, because apparently juries overlook the fact that they hate the person giving the testimony and just respect their credentials, because TV shows about court are fake. Tanu Bojangles, 3 times more. Thanks, pal. Finding that handwriting. Okay. So yeah, that's there are expert witnesses with ethical standards, but there are for-hire mercenary expert witnesses out there who have the credentials to be an expert, but they're being paid by someone, and often very well. This particular genetics expert, for example, would have cost a $2,000 upfront payment, as well as full travel and accommodations for the duration of any court proceedings. And then they would require $2,000 a day plus all expenses covered on a per diem basis. So that's the kind of costs we're looking at for expert witnesses. They make a lot of money if they have a sufficient training and sufficient credentials in a valuable field. And the more unique the field, the more valuable they are, although the less they are hired. So yeah, if that's true about the, you can find a video of the original handwriting expert appearing on CNN to explain what a guy's signature can tell you about his personality. I bet that's great. Is the decision 65 pages explaining how the judge was all set to sanction LanDUI, but the dog ate it? Pretty much. Oh, sorry, Hatbuckles, impecunious. Remember, I mentioned just a little bit ago, pecuniary damages are monetary or economic damages. So if you break down the word impecunious, it comes out to without money, without monetary resources. Nels Eklund, your FRIMAC. FRIMAC is the standard that we use in Minnesota. A FRIMAC hearing is where you challenge the validity of a various scientific test. And you would then state that maybe a test is too novel or doesn't have sufficient consensus within the field to be recognized in a court of law. Can someone be an expert witness for a living? Yes. Actually, the guy who graduated, one of the speakers who graduated from my class in law school, who made everyone else look like a slacker, was a spinal surgeon. He had he had 1 MD, 2 PhDs, a master's of business administration, and was completing his Juris Doctor at the same time that I was. And his business proposal that he was working on with another professor was to actually train people with sufficient credentials to be solid expert witnesses and teach them how to market that expertise. Yes, you can absolutely be an expert witness for a living. It can be extremely lucrative if you're in the right type of field. My buddy has a master's in music education. I helped him get a side gig going as an expert witness in music licensing cases as I introduced him to some lawyers. And I bet he makes good money at that. Donald Trump will complete the system of German idealism. All right. So let's scroll down. If you guys don't know, I've taken on a sort of intern to help me out with some of this stuff, and that is he's on YouTube as Joseph Aziz. Some of you may know him as Fox Aziz. He helps me. He has helped me with this document, and I have, to his credit, I have not gone through the entire case. He has highlighted relevant sections, and we're gonna go through it together and see if I agree on all of them. But so far, what I've read has been very good. But I want to go through this entire document at some point, but tonight I just want to get to those sanctions, because otherwise this will get very long. But here what he has highlighted is some serious mistakes of law by Kevin LanDUI, like misinterpretations of basic legal principles, very bad ones. So here we go. Here we're at defendant CIR's Rule 11 motion for sanctions. Oh, let me preface this case in case you don't know. Almasiga is the defendant. It is a woman who was allegedly the wife of a hitman for a notorious cartel in Mexico, if I remember correctly, and was interviewed on a documentary produced by CIR, and it's available on YouTube even today, if I understand correctly. And it was basically my time as a hitman for the cartel, and she went on and gave her story as the wife of a hitman for the cartel. She appeared identified in the video, and her her identity was not obscured really in any way. Do you pay your interns for their time like mean old Dick, or do they work for free like people do for Maddox? My interns and I have a very specific understanding of the monetary relationship, and the relative to their duties as interns, which are zero duties as interns. We have an understanding of how things work. So, but I will not disclose any financial relationships that we may or may not have on this stream. That's for us to decide. But so this person appears in full light and fully identified on the video, and about a year after the video aired, determined that was probably not the wisest decision, and then sued the CIR to state that they were supposed to protect her identity and didn't, under an oral agreement that was not part of the signed release. When CIR produced the signed release and said, no, this is what you agreed to, and there's no confidentiality agreement in here, they said that the signature on that signed release was forged, and that CIR was attempting to cover up the fact that they had made an oral agreement. There are all sorts of problems with these claims, but then they brought in a handwriting expert to attempt to explain this and prove that the signatures were different. That handwriting expert was then fired, and they brought in a different handwriting expert, and there are numerous problems with that expert's testimony, and we're going to talk about some of them. Sexual favors then. Will Maddox find success with a new career as an expert witness in train wreck cases? Maybe. He should probably just go to people who are preparing a frivolous lawsuit and say, don't do it. Look at the bags under my eyes and look at my failing career. Don't do it. Don't do it. Will Jesse P.S. be able to be an expert witness for being a white trash stereotype? I don't know. That would be up to him, I suppose. If the video is still available, I guess we can guess how that went. Yeah. LanDUI lost all of this. He lost all of it. As stated, the motion to dismiss was successful. And if you notice, you guys can't see it, but there are 4 parties to this lawsuit. And one of those parties is Univision, who had nothing to do with the production of this documentary, but did air the documentary, I believe. And LanDUI added Univision and was slapped down pretty hard verbally, not with sanctions, for inappropriately adding them as a party to the suit when they had no business being added. He'll be an expert witness for not hiring LanDUI. That's probably true. Okay, so defendant CIR seeks sanctions against plaintiff for allegedly perpetrating a fraud upon the court and against her counsel for willfully blinding himself to her misrepresentations. Does that sound familiar? Since the outcome of defendant's Rule 11 motion is affected by the admissibility vel non, and guys, I don't know what vel non is. If someone in the chat wants to look it up, I'm not going to pretend to know something I don't know. Of the proffered opinion of plaintiff's handwriting expert that the release was forged, the court first addresses the admissibility of that expert opinion. One of the parties is a tree Landau crashed his car into. So plaintiff actually performed services for which it is equitably entitled. Not really interested. So the admissibility of the proffered expert testimony under Rule 702. The Captain Planet of career suicide. Shortly before the expert disclosure deadline in this case, plaintiff engaged a reputed handwriting expert, Wendy Carlson, to provide an opinion on the authenticity of plaintiff's signature on the release. The signature on the release appears as follows. Now, notice there's a footnote here. A year earlier, plaintiff had obtained a letter dated August 20th, 2014 from Kurt Baggett, another purported handwriting expert, that stated that the release was forged. See Declaration of Thomas Burke dated September 14th, 2015, Exhibit 14. However, the letter did not contain any analysis. It simply recited Baggett's bald conclusion, bald conclusions everywhere, that the release was forged, and for whatever reason, plaintiff did not proffer Baggett as an expert. I'm guessing Baggett's credibility would have been in severe question. The signatures excerpted in this opinion and order are excerpted as they appear on actual documents. For that reason, some overlapping text or markings may appear in the excerpted signatures. Vel non means or not. Thank you. Thank you for looking that up. I did not take a Latin class. So let's read that sentence again. Since the outcome of defendant's Rule 11 motion is affected by the admissibility or not of the proffered opinion of plaintiff's handwriting expert that the release was forged, the court first addresses the admissibility of that expert opinion. That makes perfect sense. Okay. So on August 18th, 2015, plaintiff's counsel sent an email to Carlson asking her to provide a Rule 26 report by the next day that analyzed the release against purported known signatures of the plaintiff. Plaintiff's counsel provided numerous purported known signatures to Carlson, all of which were either dated after the initiation of the parties' dispute or were undated. So, right, do we understand what has happened here? I hope so. The plaintiff, after bringing an action stating that the signature on the release form was forged, wrote new signatures and sent them as proof of what her signature looked like. So obviously those would not look like her actual signature. A representative example of which is as follows. So here's the original signature. Here is the next one, which is clearly not the same signature, right? September 14, Burke Declaration, Exhibit 16. After comparing these known, notice the court, you can tell this judge is ticked. First of all, that he's writing a 65-page opinion at the district court level is funny enough. This is not an appellate decision. But after comparing these known signatures to the signature on the release, Carlson opined in an expert report submitted August 20th, 2015, that based on her scientific examination, the signature on the release was a forgery, id at 7. On December 4th, 2015, the court held a combined evidentiary hearing on CIR's Rule 11 motion and a Daubert hearing on the admissibility of Carlson's testimony. See Daubert versus Merrill Dow Pharmaceuticals. If you want to read that tells you about that case and how the Daubert hearings were established, or how Daubert review of expert testimony is established. At the hearing, Carlson admitted that she had no basis for knowing, other than the representation of plaintiff's counsel, that the purported known signatures she had received were actually plaintiff's, such that she could not definitively state whether the known signatures had been forged or whether the release had been forged. That's problematic testimony. Who would win in a fight? 1,000 Globalists or Alex Jones on Super Male Vitality? I mean, have you seen that man on Super Male Vitality? His shirtless roar would kill probably 900 of them. For that reason, the court asked plaintiff to write her signature on a piece of paper 10 times in open court, the in-court signatures. Although Carlson observed the plaintiff was writing these signatures very slowly. Nonetheless, at the court's request and on consent of all involved, Carlson prepared a supplemental report following the hearing, submitted on December 9th, 2015, in which she found that the author of the in-court signatures was the author of the purported known signatures that formed the basis of Carlson's initial expert report, and that once again her opinion, based on her scientific examination, was that the signature on the release was made by someone other than plaintiff, i.e. was a forgery. See Forensic Handwriting and Document Examiner Expert Report Supplement. In order for expert testimony to be admissible under the federal rules of evidence, Rule 702 requires that an expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. That, quote, the testimony is based on sufficient facts or data, and, quote, is the product of reliable principles and methods, and that, quote, the expert has reliably applied the principles and methods to the facts of the case. Notice the judge's use of the Oxford comma. LanDUI should take notes on this decision. I'm sure he could actually learn some grammar and usage tips. The proponent of expert testimony has, quote, the proponent of expert testimony has the burden of establishing by a preponderance of the evidence that the admissibility requirements of 702 are satisfied. United States v. Williams. While, quote, Rule 702 embodies a liberal standard of admissibility for expert opinions, that means it's easier than you would expect. Nothing in either Daubert or the federal rules of evidence requires the district court to admit opinion evidence that is connected to existing data only by the ipsa dixit of the expert. And let's look up ipsa dixit. That's another Latin term. A dogmatic and unproven statement. So where are we? Here. Sorry. I gotta reopen all my windows. Yeah, Oxford comma is a good drink. I love that you can see Rekieta Law look over at the chat, visibly react to the fact that the only new lines are pure nonsense, and then move along with the document. Okay, so let's read that statement again. Nothing in either Daubert or the federal rules of evidence requires a district court to admit opinion evidence that is connected to existing data only by the overtly dogmatic statement of the expert. Rather, Daubert has, quote, charged trial judges with the responsibility of acting as gatekeepers to exclude unreliable expert testimony and junk science from the courtroom. With respect to expert opinions purporting to offer scientific conclusions in particular, Daubert states that courts should ordinarily pay particular attention to whether the expert's methodology has or can be tested, whether it has been subject to peer review and publication, whether it has a known error rate, whether it is subject to internal controls and standards, and whether it has received general acceptance in the relevant scientific community. Again, an Oxford comma. Would LanDUI qualify as an expert for DUI cases? Man, I hope not. He is not good at winning them. When was this case? This case was 2015, I believe. And this case is available. All of the motions of this case are available. And I am going to thoroughly cover them in my How to Not Get Sanctioned video starring Kevin LanDUI that will be coming up. But this is kind of like a preview for that. So anyway, here he goes through pointing out all the problems with the expert testimony. And let's not dwell on this any longer, because this stuff gets long and technical, and we will, like I said, we will be going through this when we actually go through the document, and I've had time to fully vet all of my wonderful interns' highlights, and then to vet his highlights and add my own, and so that will come up soon. But let's get on to the counsel. Let's get on to this counsel. First, as a threshold matter. Oops, just a second. Sorry. Very unprofessional of me, as normal. As a threshold matter, plaintiff's counsel sought to bias Carlson, who is the expert witness from the start. In plaintiff's counsel's email, notice proper apostrophes. This is probably why LanDUI doesn't understand what he did wrong, is because the apostrophes and punctuation are correct. In plaintiff's counsel's email to Carlson seeking to retain her, plaintiff's counsel stated flatly that, quote, the question document was a release that defendant CIR forged, and that a Rule 26 report to this effect was needed from Carlson by the next day. He continued, I understand that we are asking a lot in a short period of time. However, this is what we need. We need you to state this tomorrow. And you're the expert that we want and feel comfortable working with. You were a rock star for us at our last case. We are asking the same performance here. Our client was really taken advantage of by this defendant, and it put her and her young children in danger. And we need to help you. We need your help to right this wrong. If you need anything else, please let us know. We can't thank you enough. In the same vein, one of the known signatures that plaintiff's counsel provided to Carlson was an affidavit signed by plaintiff reciting her claim that the release is a fake, which does not contain my signature. So he's poisoning the opinion of the expert witness. And if you notice, LanDUI does have a habit of trying to poison the opinions against the defendants in other cases as well. So let's see. Here we go. The tainting effect of Carlson's assumption in this regard may be gleaned from what she infers on the basis of her observation that the quote signature on the question document is written with great fluidity and a faster speed, unlike the known signatures that display a slower, more methodical and unrefined style of writing. To Carlson, who took on faith that the known signatures were accurate representations of plaintiff's handwriting, this discrepancy is evident that the release was forged. Yet, at the Daubert hearing, Carlson confirmed that slower, methodical handwriting was, quote, equally consistent or maybe even more consistent with someone trying to fake the known signatures. And she observed that the exemplars written by a plaintiff in open court were written slowly. While Carlson further testified that she was able to assure herself that plaintiff did not disguise her handwriting because, quote, subconscious traits and characteristics will reveal themselves in disguised handwriting, this testimony cannot be considered of much value in light of Carlson's earlier contrary deposition testimony and the complete absence of any indication in her reports that she was accounting for the possibility of disguise. Fourth, also diminishing Carlson's credibility are a number of striking contradictions between her report and her in-court testimony. So again, more problems with the expert, but let's see. Okay, here we go. Here's the Rule 11 motion, and this is specific to the sanctions. How is that not illegal? It's a good question. Carlucci here. Thank you for your legal counsel. I won that suit against Clay early. I recommend Nick Law Group 100%. This is satire for legal reasons. But yeah, I'm glad that you won against Clay. He deserves to be taken down a peg. All his clients are fibbers. Nels, what is the common denominator? Is it possible that all of his clients are fibbers, or is it more likely that they are getting advised to fib? I have no information on his, obviously his protected communications with his client, but there is a point where zealous advocacy tips into perpetrating falsehoods on the court to try and win cases. And it kind of looks like it. It kind of looks like it. Okay. So having determined that Ms. Carlson's expert opinion is inadmissible under Rule 702, the court turns to the merits of defendant's Rule 11 motion. Rule 11 of the Federal Rules of Civil Procedure requires attorneys filing papers with the court to certify, quote, that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, the factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. If, quote, the court determines that Rule 11b has been violated, the court may impose an appropriate sanction on any attorney, law firm, or party that violated the rule or is responsible for the violation. Guys, think of the number of unsubstantiated factual contentions in the complaint alone, much less the additional factual contentions that have been made since the complaint in motions. The implications of the Rule 11b are stunning, and this is a federal rule of civil procedure. New York probably has a very similar rule of civil procedure. Most state rules of civil procedure at least incorporate large portions of the federal rules or mirror them in some way. They're all fibbers, and LanDUI is like Bart in that science fair episode where he kept getting shocked by Lisa's trick cookie. Exhibit A, multiple DUIs. But yes, I remember how awesome street sharks were. A bunch of burly sharks swimming through asphalt is cool. I missed the past hour of the stream. What are we reading now? Real SG125. This is Almasiga versus CIR. This is a case LanDUI lost in 2015 and was almost sanctioned for perpetrating a fraud on the court. But they ruled that it was his client and not him, which we're going to talk to in just a second. Gats, who's better at illegal advice, LanDUI or Alan Shore? LanDUI seems good at illegal advice, so I wouldn't count him out. Okay, the standard for triggering the award of fees under Rule 11 is objective unreasonableness. In addition, Rule 11, quote, sanctions may not be imposed unless a particular factual allegation is utterly lacking in support. And I think we have several of those. I think, if I'm being nefarious as an attorney, maybe Maddox admitted to the falsehood on advice of LanDUI so that LanDUI didn't get sanctioned. And you can let that marinate and interpret that however you want to. But it is possible that Maddox was advised to come forward with his fraudulent assertion that that Heather S. was not him, and then that would look like LanDUI was not the person perpetrating the fraud on the court, but rather it was Maddox, and might be an attempt of LanDUI to cover himself. Although I think the butchery of the Mad Cuck statement and the addition of back to Asterios talking about going to work, adding in brackets going back to work to make it look like Asterios was leaving Weber Shandwick, going home to sleep for an hour, and then returning to Weber Shandwick, which is silly because he could probably just sleep at Weber Shandwick on a couch or bench somewhere, or in his office or cubicle. So I think there are ample instances where LanDUI is perpetrating a fraud on the court, but he may have been attempting to get Maddox to own up to it so he didn't get sanctions. Did you ever American Gladiators, though? Dude. Of course. And I love the new American Gladiators, too, and I'm sad that that went away. Although I think they were getting mad that only, like, skinny, fit dudes were winning, as opposed to burly monstrosities. But, so let's see. Indeed, Rule 11 sanctions are not warranted where the, quote, evidentiary support is merely weak and the claim is unlikely to prevail. They have to be false accusations or accusations that are completely unsupported by the evidence. Like every accusation that Dick or Asterios made some sort of defamatory or offensive or obscene claim, but they're actually attached to a fan with no link or even implication that the fan might have been a fictitious person created by Dick or Asterios. There's no factual basis for the creation of like the Encyclopedia Dramatica. None of that is supported anywhere. These are real problems here. And I think, at this point, this type of motion, if New York has a comparable rule, would succeed against specifically Maddox and possibly LanDUI. Separate and apart from Rule 11, a court has the inherent power to impose sanction on a party for perpetrating a fraud on the court. Such sanctions are warranted if it is established by clear and convincing evidence that a party has sentiently set in motion some unconscionable scheme calculated to interfere with the judicial system's ability impartially to adjudicate the action. No doubt that has happened in this case. No doubt. Accordingly, as a general matter, a court should not impose sanctions on a party or attorney pursuant to its inherent authority unless it finds, by clear and convincing evidence, that the party or attorney knowingly submitted a materially false or misleading pleading. We have clear and convincing evidence. We have beyond a reasonable doubt evidence that happened because the pleading is a complaint and Maddox admits to lying about it in his most recent affidavit. Or knowingly failed to correct false statements as part of a deliberate and unconscionable scheme to interfere with the court's ability to adjudicate the case fairly. So that might be their one defense. They corrected the false statements, although they didn't admit to lying in their pleading. They didn't put it out as a correction. It was merely a reveal in the affidavit, and it's not included in the motion documents, if you'll know. Drink water. I'm drinking tea. Leave me alone. Can I sue Nickelodeon for never getting my chance to take home a piece of the crag? Yes. My buddy works for Lagavulin. They are aware of your existence and your advocacy. Oh, that is brilliant. Man. I will advocate much, much harder, Kellen Miller. Tell him I am aware of their existence. I am keenly and to my wallet's detriment aware of Lagavulin's existence. Okay, so CIR asserts that sanctions are warranted because the totality of the evidence demonstrates that plaintiff fabricated the key factual allegations underlying her lawsuit. Plaintiff was thus plainly aware on July 13th of the fact that CIR had revealed her identity in connection with the CIR report, yet the evidence shows us that plaintiff did not raise concerns about the revelation of her identity until almost a year later in June 2014. Moreover, the signature on the release very closely... Okay, this is going back to the signature stuff, that they're perpetrating frauds upon the court. Let me get down to the conclusion, because we're going to wrap up pretty soon here. Upon further questioning, Duarte Murillo testified that he gave information to plaintiff and not her attorney, and that plaintiff and not her attorney typed the affidavit. So here we have an example of LanDUI not typing a document, but having the actual party type the document. Duarte Murillo then clarified that in fact plaintiff showed him the affidavit already typed and asked if the information contained therein was accurate. So the plaintiff perpetrated the fraud, not LanDUI, according to this third party's testimony. Are sanctions keto? Yeah, sanctions are definitely keto. We want you to stay hydrated and supple. Okay. Thank you. That's delicious. All right. So we're close to the ruling here. Specifically in this case where plaintiff's version of events was corroborated at least to some degree by others, and where plaintiff's counsel had obtained a favorable expert opinion, although this is a stretch for the judge to say, in my opinion, because he didn't obtain a favorable expert opinion. He bought a favorable expert opinion. And that seems pretty clear from the communication. When I read that email, by the way, earlier from LanDUI to the handwriting expert, it sure looked like coded speak for, we will pay you to provide the answer we request. Do you like barrel-aged beer? I'm not a huge beer fan. I have not found a beer that I like. I'm certainly open to trying pretty much anything, but I would definitely try some barrel-aged beer. I don't know if I've ever had it. Not that supple. Soda isn't water. You can't lower your way out of HFCS. Hatbuckles, this isn't soda. This is tea. This is tea in this cup. Does Maddox have a real case against LanDUI? It would entirely depend on the communications between Maddox and LanDUI, which only Maddox can reveal. LanDUI cannot, and LanDUI cannot stop Maddox from revealing those conversations if he were to bring an action against him. Maddox holds the privilege in that case, and therefore it would be up to them. So, Maddox would have to look into it and maybe discuss it with another attorney to see if he's properly being represented or if he would have a case. The barely standard is the bestest legal standard. Yeah. So counsel barely satisfied his obligation under Rule 11 to ensure through an inquiry reasonable under the circumstances that his client's factual contentions have evidentiary support. I think that his work here is much more egregious. But the conclusion we'll just read real quick. In sum, for the foregoing reasons, the court in its order dated March 31 granted defendant CIR Rule 12C motion for judgment on the pleadings and dismissed the amended complaint with prejudice as against all defendants. Regarding CIR's Rule 11 motion and accompanying Daubert motion, the court excludes the reports of the testimony of plaintiff's handwriting expert and in their entirety for failing to meet the standards of Rule 702 under both Daubert and Kumho-Tyer. CIR's Rule 11 motion is granted to the extent it seeks dismissal of the action for plaintiff's perpetration of a fraud upon the court, but denied to the extent it seeks monetary sanctions against either plaintiff or her counsel. Clerk of the court is hereby directed to enter final judgment dismissing plaintiff's amended complaint with prejudice and to close the case. So there you go, guys. That is how LanDUI narrowly avoided sanctions in this case. And I do want to do a post-mortem on this full case, because these take a lot of time, which is why I haven't done them. And they get very technical, which I know a lot of you like. But they take a ton of time, and I am pretty busy with some legal work of my own at the moment. So it's been hard to delve into the full cases, but his cases possess several hallmarks that are very familiar from the Maddox versus Masterson case. The improperly including large corporations in the hopes that you would fleece money out of them, making falsehoods or misrepresentations to the court, filing frivolous motions, demanding sanctions, and demanding silencing of the other party. These things are common to LanDUI cases in New York. And so I want to highlight that and talk about how these types of similarities are very interesting, because I think they're newsworthy in as far as, our interest in the Masterson-Maddox case. And they're certainly informative because he's routinely shut down on the attempts to do these things. So it's a style of attorneying that I don't agree with. And it's just interesting to see what kind of things people do out there. So I do want to do a full postmortem on this case, but I don't want to just read through it, because this case is, these are long documents. You can see this opinion is 65 pages. It would take many, many videos to go through all of it. And I don't want to do that for a case that there is tangential interest in. But I do want to go through and have the time to fully highlight and discuss the elements of the case beyond just the Rule 11 motion. Yes, and Fibber clients. I hate LanDUI. Is it legal to murder him? It is not legal to murder anyone in any state in this country. I guess you would have to, move somewhere where there are various death penalty, extrajudicial death penalty things, and accuse him of maybe not wearing his burqa or something like that in public. Her burqa? His? I don't know. So if this case gets thrown out for its falsehoods, does that mean that Maddox is not a writer and mental justice, not a beautiful African-American model or whatever? I think as a matter of law, yes. All right, guys. So I am going to wrap this up here. Thank you for hanging out with me tonight and yesterday. Again, I have tons of fun doing these. I hope you guys have tons of fun in the chat. And we have some non-live stream content coming out this coming week. And one more time, shilling the Patreon as you can see up above here, patreon.com/Lawsplaining. Come check it out. If nothing else, you can get audio versions of all of the YouTube videos that are done. And some people find that a little more convenient when listening later. Although, let me make a very clear disclosure. I do not edit out the live streams when I publish them, the audio versions. Because, one, it would take a ton of time. And two, this is how it happens. It's very organic, an organic process, and I don't want to dishonor that. But if you're listening to the audio of the live streams, you have to be prepared for a bunch of interruptions and chaos, because the fun of the live streams for me, and I think for the people who are watching them, is the chat is a huge portion of that. And so that's just a reality of it. I will try not to do live streams on overly information sensitive topics, because or if we do a live stream on those and people really want something specific for them, I will create a non-live stream version that is very focused on the information. So we can make sure and fulfill people's desires there. As always, if you have any comments, please drop them in the comment section. If you have criticisms, please drop them in the comment section as well. I'm creating a product for you guys, unabashedly capitalistic and for my profit, but also for your entertainment. So if there is something I can do to make this show more enjoyable, entertaining, or informative for you, let me know, and I will see if I can implement that. I have been implementing suggestions as I get them and as I'm able to, so I'm happy to do that. If there's content you want to see, let me know. Patreon suggestions necessarily get some higher priority on the content suggestions, but send me documents, send me news stories or whatever, and I will see what I can do about them. Thank you all for joining me. Let me address a couple things. Good night. Come to Alberta. We love you up here. I've only been to Canada once, but I went to Banff, and it was really, really brilliant. But I would not be opposed to making another Alberta thing. Shirtless streams, that would have to be for some high-level Patreons. I'm not going to read your Alexa demand. Thanks for helping me break in my new TV in my new place. Anytime, Jamie. And good luck in your new place. And hopefully you're still running your fitness gig. And if you're looking to get fit, look no further than someone who is very fit and has made a career out of helping people get fit. And that would be Jamie Hughes. Jamie, you can plug your website in the chat. I don't remember what it is, but you should definitely check out her information. Ashley Princess, good night to you. Jack Mehoff says, what game should I buy on Steam? I don't know, man. I'm going to buy Dragon Ball Fighter Z very soon here. A fan has sent me an Xbox controller that I can use on my computer, which I'm very happy about. But I have been playing Vermintide 2 quite a bit, which is a lot of fun. I've been playing it with a couple other fans of the show. Then let's see, keep up the good work. You should trade reading lessons for fitness lessons with Jamie. Aw. Yeah, I could actually use some personal training, but we'll see. We'll see. No Into the Breach. I've heard good things, but I haven't played it. Elite Dangerous is pretty fun. Shill Asterios is Patreon. That's a good idea. Patreon.com/Asterios. And guys, help him out. The legal bills on this are crushing to people. Take it from me, a guy who takes legal bills from people. Not everybody deserves to have to pay. And trust me, in New York City, Greenberger's a great dude, but he is also a dude feeding his family in one of the most expensive places in the country to live. So his fees are high, I'm sure. I'm sure they're reasonable and within all sorts of ethical standards, but that still means they're expensive, and Asterios could use the help. So buy the albums to help him out. Patreon him. He's a great dude, and he produces a lot of fun content. Okay, thanks as always. By the way, the only reason I was bugging you about the email was to make sure I sent it to the right place, rekietalaw@rekieta.org. Yes, that is correct. Gilhelm Lagarde, are you planning to stream yourself playing these games? If I can come up with a fun format to stream the games, I will. Kingdom Come Deliverance is on my radar. Absolutely, Malachi. I'll tell you, I do have a $20 Patreon reward that has been adjusted, but the $20 reward has been reworked. But the original reward was we would play games online, and I would produce a video of that for the Patreon who was playing with me. So that is something that I can do as well. If you get in DBFZ, be ready to bash your head against the wall that is online players. Yeah, I hear it's a pretty brutal learning curve for the online fighting, but it looks like a fun game, so I'll probably check it out. All right, guys, I'm going to wrap up the stream here. Thank you all for joining me. Have a great night. I love doing these. I'm going to probably make the Friday stream as regular as possible. And if we don't have LawSuit documents, we're going to have something. So keep coming back. Tell me what you want to hear about, and we will keep going. Anyways, until we get some new documents, peace. I'm going to blank out the screen, and once I see it go blank, I'll end the stream. Y'all have a good night.